Welcome back to Module 4. This is Lesson 2, Contracts and Business Structures. Creative work thrives on trust. But trust alone won't protect you when a client delays payment or a partnership falls apart. Contracts and the right structure are your professional safety net. Let's build it. Let's begin with why contracts matter so much. A handshake is a start, but a contract is a foundation. It turns goodwill into something you can actually rely on. A good contract protects both sides. Clear terms prevent the misunderstandings that quietly end good working relationships. It makes expectations explicit. When scope, price, and deadlines are written down, there's nothing to argue about later. And it's your safety net. When something does go wrong, the contract decides what happens next calmly and in advance. Here's a simple rule of thumb. If the work takes more than a day or costs more than €100, put it in writing. Not every agreement is a contract. Under EU law, 5 elements must all be present for it to be legally binding. 1. An offer. One party proposes clear terms, a precise proposal of what's being agreed. 2. Acceptance. The other party agrees to those exact terms without changes. 3. Consideration. Both sides exchange something of value, each gives or promises something. 4. Capacity. Both parties are legally able to contract of age, of sound mind, and authorized. 5. Legality. The purpose must be lawful. An agreement for an illegal aim simply can't be enforced. Here's the key. Remove any one of these 5 and the agreement isn't enforceable. All 5 must be present at the same time. Does a contract have to be written? Legally, no, but practically almost always yes. A written contract has its terms documented and provable. It protects you if memory fades or goodwill runs out. It's the professional standard for real work. For anything that matters, always use it. A verbal contract can be legally binding too, but it's hard to prove. It relies on memory and trust alone. One disagreement, and it becomes your word against theirs. Legally possible, but genuinely risky. And if you work across borders, know this. The Rome I regulation governs which country's law applies to a cross-border contract, essential when your clients are spread across Europe. Every strong contract covers 6 key terms. Learn these, and you can read any agreement with confidence. 1. Scope of work. Exactly what you'll produce, in what format, and by when. 2. Payment terms. Amounts, due dates, milestones, and what happens if payment is late. 3. IP ownership. Who owns the final work and what the client is allowed to do with it. 4. Confidentiality. What stays private and for how long. 5. Liability. What happens and who's responsible if something goes wrong. 6. Termination. How either party can exit the agreement and what's owed if they do. And watch out for one thing especially. Clauses that hand full IP ownership to the client by default. Always negotiate to keep the rights you haven't explicitly sold. A contract is only as strong as what it actually says, and vague language is the single most common source of creative disputes. Think of the scales of justice. Fairness comes from balance and clarity. So make 3 things unambiguous. First, define the scope precisely. Name the deliverables, the formats, and how many revisions are included. Leave nothing to assume. Second, pin down payment. Exact amounts, exact dates, and the consequence of paying late. Third, state IP ownership. Say clearly who owns what and which rights transfer and when. Your exercise here is a contract analysis. Review a real client contract and ask, what's missing? What's ambiguous? Where's the risk? Because every vague clause you leave in is simply a future argument waiting to happen. How you register your business shapes 3 things: how you're taxed, how much personal risk you carry, and how clients and investors see you. There's no one-size-fits-all, but there is a right choice for your situation. Let's compare the main structures. A sole proprietorship or freelancer is simplest, but your liability is unlimited and personal. It's best for solo creatives starting out. A general partnership shares that unlimited liability between partners. It suits 2 or more creatives collaborating. A limited partnership is mixed useful when one partner is only an investor. And a private limited company limits your liability to the company's assets. It's taxed as a company, and it's best for growing studios and those seeking funding. The names vary by country: GmbH, EOD, LDA, AO. But liability, tax, and credibility are what really differ. Once you've chosen a structure, registering it is often simpler than people fear. Here's the general path. Step 1. Log into your National Business Register and choose a unique name and an activity code. Step 2. Declare your share capital. It's often minimal in Estonia, as little as 1 cent per shareholder since 2023. Step 3. Add a legal address, sign digitally, and submit. Step 4. After registration, open a business bank account and register for VAT once you cross your country's threshold. The speed can surprise you. In Estonia, the whole thing is done online in about a business day. And in Portugal, the Empresa na Hora company on the spot service can incorporate a simple company in under an hour. So how do you choose? Weigh 6 factors and remember, your structure isn't permanent. It should evolve as you grow. Start with liability and tax. How much personal financial risk can you accept? And which structure is most tax efficient at your income level? Then the admin burden. How much paperwork and compliance can you realistically manage on your own? Then credibility. Does your target market expect to work with a registered company rather than an individual? And finally, funding and scalability. Do you need a formal entity for grants or investment? And can the structure grow with you, hire people, take on partners? Many successful creative businesses start as sole proprietors and incorporate later when revenue grows substantially or when personal liability becomes a real risk. Choose for who you are today. You can always change it tomorrow. Not all contracts are the same. Different working situations call for different types, and using the right one prevents most disputes before they start. The client service agreement is your standard contract for project work. It defines scope, timeline, payment, and IP ownership. A collaboration or partnership agreement is for working with other creatives. It sets roles, revenue splits, decision-making, and what happens if someone leaves. A licensing agreement lets a client use your work without owning it. and it can be exclusive or not. And the employment versus freelance distinction is about legal classification. Employees and freelancers have different protections and taxes, and misclassifying someone is a serious matter. My best advice: keep a small library of template contracts for your most common situations. Have a lawyer review them just once. A reviewed template pays for itself the very first time it prevents a dispute. Let's end with a habit that will save you years of stress. A reviewed contract template pays for itself the very first time it prevents a dispute. You don't need a new custom contract for every job. You need a small library of solid templates for your most common situations. One for client projects, one for collaborations, one for licensing. Have a lawyer review them just once, and then reuse them, adapting the details each time. Preparation beats improvisation. With your templates ready, you can start work fast and start it protected. That's lesson 2. You can now read a contract, insist on the terms that protect you, and choose a business structure. In the final lesson, we make it all ongoing: compliance, risk, and legal operations. This project is funded by the European Union. See you in lesson 3.